So welcome everyone to this new episode of the ESCP International Politics Society. This is the second episode of the second season of the podcast. And today I'm really thrilled to welcome Mr. Emmanuel Bourdoncle on this podcast to discuss the theory of public international law. So this episode is especially dedicated to learning for any common citizen or auditor some very common questions or issues that you might wonder on international laws, such as who created international law, how the relationships between different states are regulated, and how to attribute a responsibility also to a state when a harm is made. So without further ado, Mr. Professor Bourdoncle, it is both a great honor and a pleasure to have you today on this podcast, and I would like you to briefly recall us your main academic background and the reasons why you devoted a part of your career to public international law also.
Thank you very much, and thank you for hosting me today. I'm very pleased to be here and to talk about this subject, and theory and history of international law are topics I followed for many years, because I did a PhD in international law during several years. My previous study was also oriented around international studies and international law, and so it was quite natural for me to specialize around international law, because I did study in international relations. And I also study law, so it was a good way to conciliate these two aspects. But if we let aside this current choice, because these two kind of study I made, it was also a choice made because I also think that international law is really interesting for lawyers, but also for international relations. It's really instructive and interesting, because on the law side, on the law part, international law is a good reminder for any lawyer that the classical, the vertical legal order we know into our internal states and internal society is not the only kind of legal system, and international law demonstrates that there is a different kind of legal order and different way for law to work, and it's quite it allows to have a broader view of what law is. And in the other way, the legal dimension, I think it's a good way to better understand international relations. And law is not the only side and the only aspect of international relations, but it's a main aspect. Even nowadays, if we see international law, international multilateral systems face to many critiques, but at the same time, law is everywhere, and international law is everywhere, and works on a daily basis. And if you don't know nothing about international law, I think you miss something about your understanding of international relations. So international law is required to be aware about the international relations.
Okay, thank you very much for this first answer, and your last words are exactly the reason why we are doing this episode, as we truly also believe that it is very important for any citizen to know at least the basics of it. So before delving truly deeper into the mysteries of public international law, I would like to start a little bit with the history and the apparition of public international law, so in the two senses of the term, meaning how did it appear, and also when did it appear, and also how does it appear on a daily basis for any common relationship between two states. So as you rightly say, also public international law is different from internal law, from what we call common law. And also regarding its apparition. So common law used to emerge when a state is created and a will to regulate the people also emerges. And then the law is created by a higher authority on a submitted people. But regarding public international law, there is no real higher authority, and this is what we will discuss in the next questions. But so far, just regarding the apparition of public international law, there are two main ways for it to appear, which are different from common law. So the first way is when two states at least agree on an agreement on terms to define their relationships. The second way is by what is called customs. So custom is an implicit rule which emerged through general and perpetuated traditions over the years between some states, and that it is at some point recognized as being law. So considering those two ways, could you tell us when approximately did public international law appear, and how can this custom be integrated or not into public international law?
Thank you. I think it's a very interesting question. A very interesting question because it perfectly illustrates what I previously said about the interest of international law due to that capacity to have a broader vision about law, about international relations. And to answer to your question, I would say if you want to know when the international law appears, the first condition is to define what an international system requires to exist. For example, if you consider that international law supposes states and international relations are existing when you have independent, sovereign, modern states, so it's a classical vision of a history of international law. You think that international law has appeared in Europe around the 16th, 17th centuries. So that vision, I think, is not the good one because, as I say, it makes the presumption that to have international law, you need to have modern states. I don't think so. You can adopt a broader view on what can be an international legal order. And it was my PhD work. In my PhD work, I suggest that the first analysis and reflections on international law have appeared during the Greek and the Roman antiquity. That doesn't mean that international law was born during the Greek antiquity or the Roman antiquity, but it suggests that international law can exist without states, and I think it's the most important conclusion of that work. In that point of view, in my point of view, you just need to have independent entities from each other who developed some kind of relationships. And this kind of relationships, as soon as they are, there is a legal framework around these relationships among independent entities, you can decide it's international law. And you must know the expression, Latin expression, ubi societas, ubi ius. Where there is a society, there is law. So, since you have an international society, you must have an international law. So, when you look far beyond Europe and far beyond the 16th or 17th century, you can find international law. Not the same international law we know today, but a law which suggest a framework to organize, to manage the relationship between sovereign entities. So you do not need to have modern states to have international law. You just need to have a society which not organized on the same basis than the legal society, the internal society, without this hierarchy, just an horizontal society among different kind of individual or subject of law, which are who are equal. That's on my mind the only condition to see an international law system. And to answer to your second question about the instruments of international law, the way to create international law, is there a difference among treaty and customs? On that point, I would say no. For me, it's kind of the same kind of instrument. Why I say that? Because there is a common notion between treaty and custom, which is commitment. And it's directly linked with the idea of international law as an horizontal order, because it means that treaty and custom are just some instruments which carry on legal obligation. But where does this obligation come from? In both cases, treaty and custom, international obligations arise from the commitment of states. So in a treaty, you have an explicit commitment to a right and obligation. In custom, just requires an implicit commitment to a non-written obligation. But for treaty, as for custom, you have in both cases this notion of commitment, which is crucial into the international legal system, because this international system is organized around sovereign entities which are equal.
Thank you very much. So yeah, as you mentioned, commitment is very central. Is a very central notion in public international law, and it is a notion that we will challenge a little bit later in the further questions. But so far, I would like to focus on the first part of your answer, which was focused on what you called an horizontal system, which can allow then international law to appear. And regarding the fact that the system has to be horizontal, it also implies, contrary to common law, that there is no clear hierarchy between the subjects which create the law and the law in itself. So there is no clear submission to law. And so I would like to ask you whether you can recall us the main relationships which can exist in international law regarding the states, but also the organizations or some other relationships. And also, what does this lack of hierarchy implies, and what is the main reason of it? So you started to talk a bit about sovereignty.
And once again, everything starts with the notion of commitment. So you have to look who can commit, to know who are the subjects of international law. And the answer is quite clear. States can commit because they are sovereign. International law can commit because international organization, can commit because international organization are created by states, by sovereign states. So you already have two kind of subjects, states and international organization, who have a particular place in the international system because they have this capacity to commit due to the sovereignty of states. On the other side, you have common citizen, private entities, civil society, who can be concerned by international law because there is international obligation directly connect to them, but these entities are not sovereign, so consequently they don't have the capacity to commit to create international obligation. That's the main difference when you look after the subject of international law. And it's kind of interesting to have that in mind, because it means everyone cannot be part of the creation of international law, but in the same time everyone can be concerned by international law. And it's this difference which can be sometimes quite difficult to understand. The second thing I will say on that question is that there is another main consequences of this kind of organization of the international law. It's the impact on the topics addressed by international law. Every topic finally can be addressed by international law. To decide if a topic should be addressed or not by international law, you just have to have a state which one day say, I want that topic be addressed by international law. So it explains the evolution of the international law. If you look at the beginning, the main topics addressed by international law was war and peace, diplomacy, for example. But today, international law, the scope of international law is way much broader because states have decided that, I don't know, telecommunication can be addressed by international law, civil aviation can be addressed by international law, etc., etc., etc. So the topic addressed by international law, due to the nature in itself of the international law, can evolve, can be developed, can be reduced, and it's all to the state to decide.
Thank you. And so this does a great transition to the next question, as then we will tackle the issue of implementation of public international law in itself. As you rightly said, the topic tackled can vary over time, can vary according to the states, according to the worries of the moment internationally, and this is due to the due to the feature of sovereignty of states, which can very freely decide what topics they will address. And so this lack of a clear hierarchy and the feature of sovereignty also allow each state to choose exactly what topic they want to address and what topic they want to submit themselves to. So some states, such as the United States with the United Nations Law of the Sea, decide not to submit to some laws, to some topics. And so this might be an issue, as thus there is no general and universal system, international law system, which would be the same for every state, except for some universal rules, which we will deal later. But so far, I would like to ask you then, taking this into consideration, how archipelagic is international law, as the archipelagic feature of international law is rightly how we call this this capacity of choosing what topic to address. And also the second question is it then so difficult to manage the relationships between the states, or do they have widely signed the same agreements on the same topics?
I like this question because I think this question perfectly sum up the debates and controversy we can know on international law. To sum up my vision of that, I will say that international legal system is a universal, but international obligations are never universal. Why I say that? Because, as you say, every state can choose to be submitted to an international obligation. So, consequently, any international obligation, we can find treaty and customs, won't be universal, because one state will say, okay, I will apply this rule. Another state say, I won't apply this rule. Some states can say, I will apply that rule, but in that way and not on the other, etc., etc. So every state have a particular international law which apply to them. But in the same times, if you want that the international legal system globally works, you have to have a common understanding on some principles of international law. So, in a sense, international law is also necessarily universal, because today every state agree to say international treaty is a way to create international obligation. If you want to sign a treaty, you have to sign this treaty by someone who is in capacity to represent its states, etc., etc. So you have some principle which are universal, but the international obligations are specific to every state. I will say something like that to sum up my view on that question.
Okay, so yeah, you kind of said that actually the instruments of international law are quite universal, but there is no one universal treaty on which any state would agree.
Yes, but which is important is that common vision on the principle of international legal system. If you don't have that, you will have some very huge difficulties to have international law among states. After that, once you have this common vision on principle of international law, common vision on what are the main principles for the common international legal system, then if you want to respect the sovereignty principle, you have to recognize that every state are free to commit or to not commit to a specific international obligation.
Okay, so then I would like to challenge some rules, some very few rules, few treaties, which are still recognized as being quite universal. And so I would like you to develop for us a bit still the possibility of universality somehow. So, for instance, taking the example of human rights, which is one of the main topics being recognized as universal. Well, the tricky issue regarding that is that actually, as a state can choose or not to be part of an agreement, somehow a state could be excluded from at least a part of international law by not submitted to at least one international agreement. But do there really have no treaty to which a state could be linked? Such as human rights. This is what I learned from my classes, as I was previously a law student. Human rights, when a state decides to submit to it, then this state has the obligation to commit towards any state whatever the other states would submit themselves to it in return. So could you develop this aspect?
The topic is well chosen because human rights are one of the most interesting recent developments of international law, because in itself human rights raise some important theoretical questions on international legal system. And if you look what we are discussed since the beginning of this podcast, um, we see the main classical principle of international legal system, but human rights bring another vision on commitment, on universality of international law. That's why it's really, really interesting. And one of the main mechanism of human rights is that the fact human rights obligations are mainly universal. So to implement international human rights international obligation, we invented some new principle related to this universality principle. And for example, some states who have committed to some international human rights treaties or human rights obligation have the obligation to enforce, to implement protection on human rights, even if the situation is not on their territory, even if it concerns citizens who are not their nationals, etc., etc. So it's quite an interesting way to be in capacity to let apart the division we talked just before among the universality of principle of functioning for international law, the archipelagic feature of international obligation. Human rights suggest an answer to reconcile these two dimensions, and it's particularly interesting.
All right. So you explain basically to what extent a universal obligation to which a state submits might involve for this state to respect the obligation towards any state, even if there is no territory link, for instance, even if the citizen of this other state has no link with the state which decided to submit to it. So the kind of other side of this issue, according to me, would be when a state actually commits to an agreement, then it has the obligation to respect it, but then can it withdraw from this commitment to some extent?
I'm going to start by just adding something to the human rights topic, which I think illustrates quite well what we are talking about. In the case of a human rights obligation, the universality of this international obligation concern the state who has committed to the international obligation. So we are in the paradoxal situation where a state can commit to an international obligation. This international obligation can be universal in its nature, but in the same time, the other states who haven't committed to this obligation won't be concerned by this universal obligation. So it's something that I think it's quite difficult to understand for people who don't really know the international obligation, the international law, and that's one of the main limit of international law. I have to recognize that. And I want to say that because it's directly linked to your question about the possibility to withdraw from this engagement for every state. Every state can decide at some point to be no longer committed to some specific international obligation. It's consistent with the principle of commitment and the principle of sovereignty, which are crucial for the international law system. So one day a state can commit to an international obligation, but because it's a sovereign entity, and it implies that tomorrow the same state, always because of its sovereign capacity, can withdraw its obligation. So it's a difficulty for international legal system because it supposes there is no permanent obligation, and you already have to have in mind the fact that the states who have committed to this obligation can one day decide they are no longer committed to this obligation. And in the same time, it implies that international legal system must have some principle to manage this possibility of a withdrawal of commitment. And so there is some rule of international law to organize this capacity of to withdraw its commitments. So main of the treaty, if you look at the treaty precisely, you always find some provision regarding the withdrawal and the capacity to manage in the best way the fact that states have this capacity to withdraw to their international obligations.
Okay, thank you. And so now let's say that two states signed a same agreement, and that those two states come into a conflict regarding this agreement. Then, I have two questions. What international institution or court might be able to judge this situation? How is it designated? And also, could one of those two states then decide to withdraw and not be judged for the conflict raised?
As always in international law, everything begins and ends with the commitment and the sovereignty. States can sign what they want, can sign agreement, but when you start to look at how this treaty will be implemented, how states will put into force their international obligation, and just the first step of any implementation of law starts with interpretation. And one of the particularities of international law system is there is no one unique centralized entity to interpret international law. So two states can sign the same agreement, but the two states still have their own capacity to interpret the same agreement. And consequently, if the first state say you have to interpret this obligation in that way to implement the treaty in that way, the other states can, without any contradiction with the law, say, for me, I interpret the rule in that way and I will implement it in that way. And once you have this situation, you have two possibilities. One, these two states can consider, okay, everyone will implement in their own way, and we will see if it works or not. The second, and it's perfectly complying with the international law, this kind of situation. It's very different of what we know on the internal legal order. Of course, if you start to say with the police, no, I don't have the same interpretation that you of this rule, you will hand in front of a judge, and the judge will be the only one to have the capacity to interpret the law. On the international system, it's not the case. So the difficulty finally just raised when these two points of view on the same obligation will be an issue to correctly implement the treaty. So first of all, the states concerned will have to decide, is a different point of view, is a matter or not. It's the first step. If they decide it's a difficulty, then they have to decide if they want to submit this difficulty to a court. And once again, because of the commitment, because of the sovereignty, they can choose or not to submit this dispute to a court or a judge. So there is no automatically a way for an international court or an international tribunal to be involved in a dispute related to international system. So it's also a specific aspect of the international law, which can be difficult to understand when you are not into international law, but it's quite important and consistent with the general organization of the international legal order.
Thank you very much. So now we're coming to the last question. And now that we have globally, widely depicted the main situations in which international law can be implemented, I would like finally to come to the issue of responsibility of the states. It is, I think, a very also tricky issue of international law, as responsibility can be easily attributed when it comes to individuals and to common law, as there is a clear hierarchy, a clear authority beyond people. But when it comes to states, it is much more difficult to attribute a responsibility to a state, because it is not easy to identify the only one and real author of an illegal act. So, could you tell us what are the main conditions for an illegal act to be attributed to a state? And would you have an example from the news for it?
You are right to say responsibility is one of the main issues of international law, especially today. It's quite clear because we see that an international law system is existing. We have seen that this international legal system can address the topic they want. It concerns states, international obligations, citizens, private companies, etc. So it's quite broad. But the main difficulty is after that, how to implement, and if you are not complying with international law, how the state's responsibility can be engaged. On that, you find a part of international law which deals with the responsibility. So it's also a good reminder that international law system is a true legal system, because there is a dedicated part of international law which deal with the topic of responsibility. The main conditions are quite simple. The necessity to have an act, an illegal act, which not comply with the international obligation, and the necessity that this act has been made by someone who has the capacity to commit for its states. So it must be a representative of the states, etc., etc. When you say that, you can see a lot of examples of an illegal act by states. For example, the invasion war of Ukraine by Russia is clearly a violation of the United Nations Charter. It's quite simple. It brings me to have a final and maybe a more optimistic reflection of on international law. Is that we, and I say it's for me, for you, for everyone, we always focus on the violation of international law. It's in a way the difficulty for international law, we talk about international law when international law is violating, basically. We talk about international law regarding the situation in Middle East, regarding the situation in Ukraine. We comment, we speak about the last Donald Trump declaration regarding the international navigation, etc., etc. So we talk about that when the things are going wrong. But at the same time, every day, most of the international obligations are perfectly implemented without discussion, without question, without difficulties. For example, each time you call people in a foreign state, international law applies. Every time you take a plane to fly abroad, international law manages the capacity to for aviation to go through frontiers, etc., etc. So basically, every day, 95% of the international law are perfectly applied without any violation, but no one talks about that. Everyone wants to focus on the violation of international law, and the difficulty is that you say, oh, international law is violating on an everyday basis, so international law does not exist. But it's not a very useful thought, because it's quite the same if I say every time there is a murder, there is no internal law. You won't say that. It's not because there is a murder, there is no law in France. And the same on the international level. Sometimes international law are violating, but most of the time it perfectly comply.
Okay, thank you very much for these last optimistic words. Thank you very much for coming to this podcast, for your time and your very enlightening answers, Mr. Bourdoncle.
Thank you very much.
To our listeners, information, knowledge is a weapon, so don't miss our next podcast to carry on arming your spirit, and until then, keep exploring the legal horizon. Thank you very much.